This is part 2 of a legal brief challenging the granting of an automatic divorce. Part 1 explained how the letter of divorce law doesn't actually allow a court to automatically grant a divorce to a spouse asking for it if the other spouse doesn't want it and can present evidence of a marriage relationship that really isn't that bad. The law says before a divorce can be granted, there has to be evidence that the legitimate objects of matrimony have broken down and that there remains no reasonable likelihood of their reconciliation. There has to be evidence. You don't just say it, there has to be evidence. You have to prove it. The problem is that apparently no court has bothered to define the legitimate objects of matrimony or how one can prove that they have broken down and prove that they can't be resolved. This brief argues that children are certainly considered legitimate objects of matrimony, so a spouse who doesn't want the divorce should be allowed to argue that the divorce would not be in the best interests of the children. Or in other words, that those particular legitimate objects of matrimony have not broken down, but would be broken down by granting the divorce. Big brown house, family, mom and dad, brown puppy, 4 children. Mom wrote books, dad taught in school, kids grew by the golden rule, child heaven. But parents play, children pay, parents stray, children pray. One of the saddest things we see today, the more parents play and children pay. So the house moved out of town, apartments, no loud dogs around, just quiet. Visitation, Christmas Eve, cry when the clock says time to leave, can't fight it. When parents play, children pay. When parents stray, children pray. One of the saddest homes we see today, the home where parents play and children pay. Judge says you get custody, I can't judge morality, go play now. I look at all you've done to your kids, set pulling up their anchor. Parents played, children paid. Parents strayed, children prayed. One of the saddest things there is today, the home where parents played and children paid. Church board warns, don't get off track, trying to get your children back. Preach the gospel. Actions just get in the way, laws won't help. These latter days are awful. Christians sleep, demons scream, lovers leap, children weep. Families are under siege by policies which discerning Christians chased like sheep. When parents play, children pay. When parents stray, children pray. One of the saddest homes we see today. The home where parents play and children pay. Part 2 takes up after that, where the second legitimate object of matrimony proposed for the court's consideration is the family finances. So here, this is a model brief, a sample brief that a spouse might submit in their defense to resist the automatic granting of divorce. So it might read like this: my spouse's petition is inconsistent with my spouse's appreciation of the need for sound finances. It is unlikely that there is any financial benefit of divorce that can reasonably compensate him for the very real losses he will sustain, not to mention the losses I will suffer. Each of us has already suffered the loss of about $10,000 in legal fees. That is $20,000 so far. That has essentially eaten up any potential profit from the sale of the home in which we raised our family. Of course, at this point, anyone would personalize this brief by inserting one's own financial details, but this is just a sample. So continuing, in regard to the present situation, it will be much easier to recover if we can stay together than if further harm to our finances comes from an order for dissolution. Okay, now here's a third proposed legitimate object of matrimony: the moral order and peace of society. This is a phrase taken from an Iowa Supreme Court case in 1975. It was actually a legitimate object of matrimony proposed by the Iowa Supreme Court. The moral order and peace of society. It's a little more challenging to imagine what this phrase rightfully, legitimately encompasses. Surely the most obvious, most irrefutable benefit to the state of Iowa in following the steps in Iowa law designed to protect the marriage bonds would be the legitimate state interest in having Iowa courts follow Iowa law. How can the court be satisfied from the evidence presented? The requirement in Iowa Code 598.17 before a court is allowed to order a divorce when the court does not allow evidence to be presented. How can this requirement for evidence be satisfied by mere allegation of one party unsupported by evidence, which the other party is not allowed to counter with evidence, cross-examination, depositions, or argument? How can a court lawfully order a divorce after not only not satisfying the evidence requirements of 598.17, but also not enforcing the tiny baby steps towards saving the marriage required by 598.16, paragraph 2, involving counseling? I applied for a conciliator. 2 months of counseling are required by law. My spouse attended only 2 counseling sessions, and there have been no consequences. There has been no application for a waiver from the requirements of this section as described in paragraph 7, nor has the court granted any waiver. The counselor said the court order meant nothing. In his opinion, my spouse's disinterest made counseling useless. I still want conciliation with a counselor who is willing to honor a court order. Since the law says no particular license is necessary for a counselor, and since my spouse and I are both active church members, I recommend a pastor. The duty of courts to weigh and rule upon the issue of whether there really is no reasonable hope of reconciliation for my spouse and me is not a mere cursory, distracted glance at the most superficial evidence, but is described in Canon of Judicial Ethics number 19, listed in Black's Law Dictionary, 4th edition. The 36 canons were reduced to only 7, about the same time that no-fault divorce was enacted. Now, I have to hope that the canons were reduced to 7 because the other 29 were considered to go without saying, and not because judges lost interest in being that ethical. So here is canon number 19, which ceased to exist in 1970 as official ethic for judges. Canon number 19, in disposing of controverted, that is, disputed cases, a judge should indicate the reason. Is there another kind of case other than a disputed case? Anyway. In disposing of controverted cases, a judge should indicate the reasons for his action in an opinion showing that he has not disregarded or overlooked serious arguments of counsel. He thus shows his full understanding of the case, avoids the suspicion of arbitrary conclusion, promotes confidence in his intellectual integrity, and may contribute useful precedent to the growth of the law. Now, should the court decide not to follow this statutory and case law, the rules of civil procedure at least allow me to enter this evidence as an offer of proof to preserve the issues on appeal. All right, here is another proposed legitimate object of matrimony for the court's consideration. America's economy, which is a subset of the moral order and peace of society. The United States economy is on the brink of collapse from an unsustainable deficit that is adding $1.5 trillion to our $16 trillion debt every year. Divorce in general contributes significantly to this looming disaster in several ways. It causes households to double their housing expenses, pushing families into insolvency, debt, and bankruptcy, which in turn threatens the businesses they owe. Divorce lowers the academic performance of children of divorce, which lessens the productivity of the nation. Divorce causes higher crime rates among children of divorce, which in turn taxes our prison and welfare system, besides destroying some of the productivity of their crime victims. Only by the legal fiction that reality is irrelevant to law can any court rule that there is no legitimate state interest in slashing divorce rates, especially when the way to slash divorce rates is to simply follow the law. In the absence of case law defining the legitimate objects of matrimony clearly enough to instruct courts in following Iowa Code 598.17, I will suggest one more legitimate object of matrimony: the mental health and happiness of the spouses. A little footnote. I observed in a previous footnote that happiness depends entirely, really, on one's decision and resolve to learn, and very little, perhaps not at all, on external circumstances. But a careless decision to sever family bonds is not an external circumstance. So if the court senses that this decision is being made carelessly or prematurely or immaturely, the court will contribute to the decider's happiness by encouraging him to decide more carefully. A fourth legitimate object of matrimony, which I propose in addition to the legitimate objects implied by the 1975 Iowa Supreme Court case Kraft versus Kraft, is the mental health of each family member. With this, I will throw in a legitimate object proffered by Kraft from very old Iowa case law, and that is happiness. The evidence will fail to reveal any good reason for this divorce. This divorce doesn't make any sense. There's plenty of potential in this marriage for a long, happy love affair, and my spouse would not likely prove an exception to the 73%, quote, 73% of women and 65% of men who think the divorce might have been a mistake and that they should have tried harder to work things out. This was of people surveyed 1 year after the divorce. This is from research, a summary of research about the effects of divorce on families by Robert B. McCall, PhD, and C.S. Holly Stocking, the Boys Town Center, Boys Town, Nebraska. It's a 1980 study. Well, it's not necessary here to repeat the evidence the divorce threatens my own mental health and happiness. That should be obvious to the court from the passion of my response and my readiness to jump in way over my head to plead for rights, which my eyes tell me are in the law despite the unanimous objections of people with genuine legal experience. Another footnote about happiness being governed by external circumstances. Although you can learn to be happy in any circumstances, while we are still learning, it can certainly seem like happiness is governed by external circumstances. And very little in this world is more cruel than divorce. Back to the train of thought, the court may not realize unless I explain that my spouse's petition is actually contrary to my spouse's own publicly professed beliefs in the Bible that warn that divorce, except for the gravest of causes, is not right. The court should weigh whether some degeneration of mental health might result later, such as guilt or depression, from the court helping him do what the Bible that he believes in warns is wrong. Should it be alleged my spouse suffers any mental difficulty already, which I have somehow caused, the court should carefully weigh whether the evidence indicates it has anything to do with me, or might rather be increased by severing our family bonds. Here's a quote from the scriptures which we both believe. Matthew 19, verses 4 to 6. Have ye not read, Jesus talking, that he which made them at the beginning made them male and female, and said, For this cause shall a man leave father and mother, and shall cleave to his wife, and they twain shall be one flesh. Wherefore they are no more twain, but one flesh. What therefore God hath joined together, let not man put asunder. This is not only what my spouse believes, it is God's plea with the court to follow the intent of the law conscientiously. My spouse shares my reverence for Scripture, the written record of God's laws, which both he and I believe will one day judge all law. In parentheses. Now suppose some domestic abuse has been alleged, which was never alleged or proved as being remotely serious injury. Now, here's how one might deal with it in a brief like this, challenging the granting of the automatic granting of divorce. Again, this is a sample brief. Now, should this alleged domestic abuse ever become a factor in a ruling, I would argue that there is too great a legitimate state interest in preserving marriage to order this destruction of our family bonds without any regard for the evidence required by the Iowa Code and Iowa appellate precedent on the basis of an unproved and unpursued charge over an injury which, even had I caused it, would not be regarded as serious by anyone over 6 years old. A lawyer told me that even if a court would entertain evidence of a breakdown, my spouse could introduce evidence of his injuries upon me. To establish the breakdown. And that would stomp out any judicial sympathy for any reasonable hope of reconciliation. Should the court ever consider such an argument, I would respond that in my view there has been nothing serious enough to warrant divorce, and that if it is my own safety or happiness that would motivate the court to remove me from such danger, I would request jurisdiction to judge. I would request that I have jurisdiction to judge what will injure me most. The risk that my spouse might injure my body, or the certainty that the court would tear out my heart. Now here's a quote from a real neat Reader's Digest article I came across many years ago. Do we imagine that divorce, the marriage is only worth continuing if we live as angels once were believed to live, soaring, free, unencumbered? People say of marriage that it is boring, when what they mean is that it terrifies them. Too many and too deep are its searing revelations, its angers and its rages, its hates and its loves. They say of marriage that it is deadening, when what they mean is that it drives us beyond adolescent fantasies and romantic dreams. They say of children that they are piranhas, brats, snots, when what they mean is that the effect of parents on the future of their children is now known with greater clarity and exactitude than ever before. Being married and having children has impressed on my mind certain lessons, and most of what I am forced to learn about myself is not pleasant. The quantity of sheer, impenetrable selfishness in the human breast, in my breast, is a never-failing source of wonderment. I do not want to be disturbed, challenged, and troubled. Huge regions of myself belong only to me. Seeing me through the unblinking eyes of an intelligent, honest spouse is humiliating. Trying to act fairly to children, each of whom is temperamentally different from myself and from each other, is baffling. My family bonds hold me back from many opportunities, and yet these bonds are, I know, my liberation. They forced me to be a different sort of human being in a way that I want and need. Well, this next section of this model brief challenging the legality of automatically giving someone, a spouse, a divorce, regardless of any evidence whether the marriage makes any sense. The next section is, it might raise questions, well, are you asking if we go back to the false system of divorce that the nation had before 1970? So this section is the difference between the rights I demand under Iowa law and the false system before 1970. Our system of justice has taken great pains to assemble men of wisdom and to ask them to be satisfied from the evidence presented whether this marriage should in fact be dissolved. That's the reading of divorce. That's phrases from divorce law. But since Iowa courts are not accustomed to considering evidence as required by Iowa 588.17, and since the court remembers that the purpose of the change to no-fault divorce in 1970 was to end the days when petitioners had to prove their spouses were monsters before they were allowed to divorce, there may be confusion how it will be possible to admit evidence pertaining to 598.17 without upending the entire legislative intent of the switch to the no-fault divorce code. The pressures since 1970, were the law followed faithfully, would be just the opposite and much less acrimonious, that is, starting arguments, than under current practice even. The spouse who wants to save the marriage will need to be as reasonable as possible and to portray his or her spouse as responsive to reason. And even the spouse who does not want to save the marriage will not want to portray him or herself as too unreasonable in order to prove his intent to destroy the legitimate objects of matrimony, lest that prejudice the court in other matters and scandalize all who hear of it. And if that spouse tries to portray the other spouse as very much more unreasonable than testimony and fact support, that spouse will risk making a similarly bad impression, being seen as so unreasonably vindictive as to fabricate transparently false accusations. Now, let it be noted that 598.17 is very definite about requiring evidence of a marriage breakdown before a divorce can be granted, and where, in any other court in America besides divorce court, has it ever been heard that where one party may submit evidence, the other party may not contest it, may not cross-examine it, may not offer opposing evidence? There's no other possible construction or interpretation of 598.17 Iowa Code but that evidence of marriage breakdown was intended by the legislature to be challengeable. The legislature never intended that every application for divorce be automatically granted, regardless of whatever evidence a resisting spouse might wish to submit. The only change the legislature wished, according to this code section, was that courts no longer make a determination which spouse was the more at fault. It's enough to know that the legitimate objects of matrimony have been destroyed, without having to chronicle which monster destroyed them. It may be that the legislature also believes some couples are simply incompatible without either spouse being guilty of anything. The law doesn't say that, and I personally don't believe there are such couples, although I acknowledge there are spouses who mutually lack the mental self-discipline or the maturity to accommodate one another. Unfortunately, easy divorce has taken the pressure off such spouses to grow up. Divorce is their easy way out of a situation that requires more maturity than they care to muster. Now, of course, as noted earlier, if Even if this factor may be found implicit in the Iowa Code, it is too vague, too relative, and too subjective a standard to be very helpful. Do not mistake my request that the court consider the possibility that the decision to divorce might be immature for an insinuation that my spouse might be immature in general. He certainly is not. He or she has not been unfaithful, nor is he or she guilty of any other fault capable of destroying the legitimate objects of matrimony. And if he were found guilty of something, he would not defiantly refuse to repent. My spouse would not threaten to consciously disobey God or this court because he will not. If this court agrees the pronouncement of our legitimate objects of matrimony is destroyed is premature, my spouse will respect that and try to work with that. No Iowa appellate, just like in any other case, if a court rules that someone has to do something, most people are inclined to respect that, or at least fear that. No Iowa appellate court has ever challenged the principle articulated in California in a case called McKim versus McKim, 1972. Here's a quote from McKim case. Evidence of specific acts of misconduct is improper and inadmissible except where child custody is an issue, and such evidence is relevant to that issue, or at the hearing where it is determined by the court to be necessary to establish the existence of irreconcilable differences. Look, did you hear that? The California court said it's necessary to establish the existence of irreconcilable differences. The court, continuing with this, the quote from McKim. By the way, McKim, M-C-K-I-M. Anyway, the court noted that the basic substantive charge in the basic substantive change in the law resulting from enactment of the dissolution of marriage statute was the elimination of fault or guilt as grounds for granting or denying divorce and for refusing alimony and making unequal divisions of community property. This end of the McKim case. The second reason for hearing evidence of factors contributing to the marriage breakdown is to show that by any reasonable definition of the legitimate objects of matrimony, the legitimate objects of this union have not been broken, but will be broken if the court adds its weight at this time to the forces attacking this union. California, in the McKim case cited above, in defining their similar statute, said that although the legislature, quote, intended that as far as possible dissolution proceedings should not be adversary, it did not intend that dissolution of marriage could be obtained upon consent alone, or that findings of the existence of irremediable differences should be made perfunctorily, in other words, automatically. The California, and this is the end of the quote, the California court noted that the legislature had rejected a proposal under which the court could have been required to dissolve a marriage upon a showing that the parties had taken certain procedural steps and that a certain period of time had elapsed. The court pointing out that the public was interested in the marriage relation. The public was interested in the marriage relation and the maintenance of its integrity, and that the law wisely required proof of the facts alleged as grounds for a dissolution. Continuing the McKim case, quote, quote, the decision of whether the evidence advanced supports findings that irreconcilable differences do exist and that marriage is broken down irremediably and should be dissolved is to be made by the court rather than by the parties. By eliminating false and wrongs as substantive grounds for dissolution, and by requiring the consideration of the marriage as grounds for dissolution, and by requiring the consideration of the marriage as a whole, and making the possibility of reconciliation the important issue, the court reasoned the intent of the statute was to induce a conciliatory and less charged atmosphere which would facilitate resolution of the other issues and perhaps effect a reconciliation. Do you see how much alike this reasoning is and the Iowa Supreme Court reasoning in Kraft versus Kraft, 1975, and how alike California law and Iowa law are on these points? That, by the way, background, the California and Iowa were the first two states to institute no-fault divorce. They both did it in 1970. Anyway, that same California court denounced, quote, the fallacy of an argument that the legislature, by enacting the dissolution of marriage law, had delegated the function of dissolving marriages either to any litigant who wants to have his or her marriage dissolved, or to the absolute discretion of the courts without any guidelines whatsoever. That reasoning is like Kraft versus Kraft, the Iowa case, 1975, which has never been overturned or challenged. And the Kraft case says, the statutory requirement for a dissolution of marriage, the marriage breakdown be established by competent evidence, is mandatory and may not be satisfied by parties' stipulation to that effect. A stipulation is a written mutual agreement, and a stipulation is one of the first things that happens in a divorce proceeding. The person who wants the divorce is called the petitioner, and they make up a legal paper that alleges that the legitimate objects of matrimony have broken down and there remains no reasonable likelihood of the reconciliation. Then the other person served that paper by the sheriff. I was served my divorce paper on my birthday. That person is called the respondent, and that lawyers instruct their respondents to say, I admit that the legitimate objects of matrimony are broken down. Now, both parties have agreed that the marriage is broken down. That is the definition of a stipulation. And what we just saw in the Kraft case is that the requirement for evidence can't be satisfied by the party's stipulation that the marriage is broken down. Well, that's the end of my sample brief. Now, I want to answer an objection that I most encounter to my effort to take Iowa divorce law this seriously. I've been asked, now supposing the legitimate objects of matrimony have been defined and evidence shows they have not broken down except for immature stubbornness of the petitioner, that is, the judge agrees that the petitioner would readily return to the marriage if he could be made to think clearly. Now, so my question is, Does Iowa law allow that stubbornness to make moot or to cancel out all other evidence? Or number two, ought Iowa law make stubbornness dispositive evidence, that is, all the evidence that you need of a marriage breakdown? Or number three, can anything be accomplished by resisting that stubbornness? To answer number two, ought Iowa law make stubbornness all the evidence you need of marriage breakdown? Now, clearly, the legislature had in mind a higher standard of evidence of breakdown than mere stubbornness, because if stubbornness were dispositive evidence, the petition alone would satisfy the court without further evidence. And yet, the words of the law require further evidence, plainly stating that the allegations of the petition must be proved with additional evidence besides the petition itself. Now, of course, it's been assumed these 43 years that the petition itself is dispositive evidence, notwithstanding the lip service to the contrary in the 1975 Kraft case. But Iowa law is not satisfied with evidence of mere stubbornness. Number three, should Iowa law make stubbornness all the evidence you need? Now, all kinds of cases come before courts. In any other case, are the responsibilities of a litigant that's a party to a case, are the responsibilities of a party to the case dismissed because the judge determines he is too stubborn to accept them? More to the point, are rulings in other cases stupid to impose on reasonable parties, responsible parties, the obligation to fulfill their responsibilities? Should a thief or a doctor be relieved of paying restitution on the grounds that he is too stubborn to pay? Should a rapist be relieved of the therapy requirement in his sentence if it is determined that he is too stubborn to attend, or that he will refuse to interact with a therapist? Should a businessman be excused from standing behind his product if it is determined that he doesn't want to? Can a lawsuit be dismissed on the ground that the respondent doesn't want to be sued, or doesn't want to correct or compensate the harm he caused? Is the harm caused to other people by someone's immature stubbornness irrelevant in divorce or in any other case? If so, does law have any meaning? What does the word law mean? It's imposition. Imposition of responsibilities. Regardless of how stubborn you are about not wanting to be responsible. So, what would it look like were these concepts of law restored to family court? What would happen to a family in which the petition is denied without healing the hearts? Now, of course, the petitioner, this the person wanting the divorce, could do what every judge and divorce lawyer assumes he will do to frustrate any attempt by the court to save the marriage. Just get worse and worse until there's no benefit remaining to the other spouse or family members anyway. But under Iowa law, as I understand it, the other spouse would have something to say about that call based on real life experience. The court would not make that call all by itself. After locking into a spare closet its own common sense and decency, and ruling only on the basis of absolute cynicism that in no case can a firm hand or wise words from the bench ever sober immature stubbornness. This application of divorce law, as I understand it, would permit judges to exercise their wisdom and compassion without seeming controversial, because that would become just part of their job. It may be that some divorces are necessary, but not this many. Courts are charged by Iowa law and by the laws of virtually every state with at least trying to save marriages. Big brown house of family, mom and dad, brown puppy, 4 children. Mom wrote books, dad taught in school, kids grew by the golden rule, child heaven. But parents play, children pay, parents stray, children pray. One of the saddest things we see today, where parents play and children pay. So the house moved out of town, apartments, no loud dogs around, and just quiet. Visitation, Christmas Eve, cry when clock says time to leave, can't fight it. When parents play, children pay. When parents stray, children pray. One of the saddest homes we see today, the home where parents play and children pay. Judge says you get custody, I can't judge morality, you'll play now. I can look at all you've done to your kids, set pulling up their anchor. Parents played, children paid. Parents strayed, children prayed. One of the saddest things there is today, the home where parents played and children paid. Church board warns, don't get off track, trying to get your children back. Preach the gospel. Actions just get in the way, laws won't help. These latter days are awful. Christians sleep, demons scream, lovers leap, children weep. Families are under siege by policies which undiscerning Christians chase like sheep. When parents play,